Item number is item number 1 from affiliate side Delhi Congress. Who is appealing? Mr. Photo. Yes.
Well, may I audible, my lord?
Yes, audible.
Well, am I audible, my lord?
Yes, you are audible.
My lord, item 1 and 2, my lord, it was wrongly filed.
Yes.
And two, my lord, two overall matters that it ought to have been filed, my lord, in a single petition.
Yes, it's a composite petition should have been.
Yes, I have gone through it, my lord. It cannot be done.
Because one writ petition has been filed claiming interest and gratuity.
Yes.
Two other writ petitions have been filed for refund of two sums.
Two sums. It cannot be done, my lord.
Which petitioner had to deposit. Now, after first writ petition, in the second writ petition, there is no disclosure that the first writ petition has been filed.
Yes, yes.
The third writ petition, there is no disclosure that previously two other writ petitions have been filed.
Yes, yes,
And
yes,
all
yes.
the three writ petitions are appearing in the list on the same day, in the cause list on the same day against different serial numbers.
Yes, my lord, I have gone through it, my lord. It cannot be done.
How much cost is to be imposed upon the petitioner? It's a abuse of process of law.
Yes, my lord.
So let me, before getting an order for refund, let me pass an imposition of cost of rupees 50,000 to be paid to the Legal Aid Services Authority of North Bengal.
My lord, only, my lord, one submission I am making, my lord, there is no scope for interest on gratuity, my lord, that I am withdrawing. Only, my lord, if your lordship kindly grant me liberty to file afresh with the overdrawn matters, then, my lord, because the gratuity interest matter, my lord, there is nothing.
Mr. Mitro, that I will grant you, but subject to payment of cost of rupees 50,000.
My lord, kindly not, my lord. He's a junior, my lord. He should have learned, my lord, in this process of time.
Mr. Mitro, this is happening here. This is not the sole case.
Yes, my lord, that I am told why you have done this. Because
in cases I had to pass an order, but now I have come to a conclusion that a strict order has to be passed imposing cost in order to send message to the advocates who are doing this mischief.
My lord, only, my lord, kindly, my lord, do one thing, my lord, kindly not impose cost. Madam, withdrawing all the matters. Only, my lord, the overall matters, if your lordship grant me leave. At all, my lord, I am leaving up to your lordship, my lord. It is not only a, my lord, a process, my lord, I have astonishing to see, my lord, when the, my lord, remedy is available, the overall remedy is available.
By way of a composite writ petition,
Yes, one writ petition will do. My lord, really,
since petitioner is a pensioner,
yes.
I will not impose cost, but I will dismiss all the three writ petitions and grant the petitioner leave to file a composite writ petition, clubbing all the
yes.
which petitioner has made in this writ petition.
Yes, my lord. Kindly, my lord. I am very, my lord. Kindly do that. What do you ask, Chana?
three writ petitions are taken up together. Wait, no, three writ petitions. No, তিনটে writ petition পরপর serially দেব। Three writ petitions were appearing in the court list dated 13 July 2023, 13 July 2023, against different serial numbers, filed by same petitioner. Where appearing, filed by where appearing in yesterday's post list or in the positive petition filed by same petition.
Against different serial numbers filed by same
Filed by same petition. So, having seen that these writ petitions were filed by same petitioner, yesterday this court directed that all these three writ petitions to be would appear in the post list dated 14 July 2023 under the heading to be mentioned. So, accordingly, these three writ petitions are appearing in the list again. Next paragraph. At the time of hearing of these three writ petitions, it is found that WPA 1429 is the first writ petition where petitioner has paid for refund of overdrawn amount. Where petitioner has paid for refund of sum, refund of sum, which petitioner had to deposit at the time of processing his pension case on superannuation. Stop. In the second writ petition being WPA 1443 of 2023, petitioner has also paid for refund of
overdrawn. Refund of overdrawn, my lord.
different sum, which petitioner had to deposit for processing his pension case. In the writ petition being WPA 1443 of 2023, petitioner has not disclosed that he has filed another writ petition claiming refund of sum, claiming refund of different sum. Stop. Subsequently, petitioner filed third writ petition being WPA 1459 of 2023. Claiming interest on gratuity paid to the petitioner at the time of releasing retirement dues. Stop. In the third writ petition, petitioner has not disclosed that he has filed two other writ petitions claiming refund of different sums. Stop. Next paragraph. Today, on query, Mr. Saurabh
Mitra.
Mr. Saurabh Mitra, learned advocate, tenders unconditional apology on behalf of the petitioners. On behalf of the petitioner, tenders unconditional apology on behalf of his client. And he has admitted that in a composite writ petition,
my lord.
the prayers made in 3 writ petitions should have been made.
My lord.
Next paragraph. This court was inclined to impose exemplary cost upon the petitioner for abusing due process of law by filing 3 different writ petitions. However, Mr. Mitra has submitted that petitioner is a retired person and inadvertently inadvertently steps have been taken. Inadvertently, wrong steps have been taken. Now, inadvertently, inadvertently aforesaid 3 petitions were filed. Next paragraph. Considering having found that the petitioner is a pensioner claiming some benefits relating to pension, unconditional apology expressed on behalf of the petitioner by the learned advocate is accepted. Stop. Next paragraph. All the 3 writ petitions stand dismissed. As withdrawn. Now, next paragraph, all the 3 will stand dismissed. The learned advocate representing the petitioner has also submitted that petitioner willing to withdraw all these 3 petitions, but has prayed for leave to file a composite writ petition covering all the prayers as made in 3 different writ petitions. Stop. Next paragraph. In consideration of the prayer made on behalf of the petitioner and on being found that the petitioner is a pensioner, the court is not imposing cost upon the petitioner, but a word of caution is given to the petitioner that if same thing recurs in future, the same shall be dealt with appropriately by this court. Stop. Next paragraph. On accepting unconditional apology, the 3 unconditional apology, these 3 petitions are dismissed as withdrawn with leave granted to the petitioner to file a composite writ petition claiming to file a composite writ petition. Stop. Urgent Xerox certificate.
I am deeply obliged, my lord. But it should not have been done, my lord.
Next.
My
Item number 4.
Head teacher of a primary school, gaining interest in Calcutta and
Just a minute. Retired
29th February 2015.
first PPO
30th March 2016.
31st 30 30
March 2016.
March
March 2016.
16
And
revised PPO
revised note 7 October 2020. Revised
7th October 2020.
revised 2019.
Affidavit of service, state affidavit of service. Next paragraph, petitioner was a retired head teacher of a primary school who retired on superannuation on 29th February 2016. So, on superannuation of the petitioner by issuing pension payment order dated 30 March 2016. Retired dues were released in favor of the petitioner. Stop. Subsequently, there was revision of pay of the petitioner in terms of ROPA 19 rules, and accordingly, revised pension payment order was issued on 7th October 2020, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Stop. State respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance, West Bengal, and the concerned Treasury Officer are directed to pay interest at the rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from the date from 14th February 2020 till the date of release of revised gratuity, within a period of 8 weeks from the date of communication of this order. Item number 5. Thank you for the permission. Yes.
High school minor retired on 30 November 2022.
Retired
on 30 November 2022.
30th November 2022. PPO
minor 4/2023.
interest on gratuity.
Yes.
Petitioner was state affidavit service filing affidavit service code line 10. Petitioner was assistant teacher of high school who retired on superannuation on 30 November 2022. Stop. On superannuation of the petitioner by issuing pension payment order dated 4th April 2023. Retired dues are released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delay. Stop. State respondents. Stop. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of legal lesson, within the period of 8 weeks from the date of formation. The rest of the paragraph to be
6. Number 6. Mother, assistant teacher of primary school.
mother of the petitioner. Where is the pension payment order?
Mother name. Mother page 14.
Died in harness
No, I died.
after retirement.
I Rupa 2009.
Just a minute. Yes, the petitioner is nominee. Mother,
Assistant teacher of primary school.
yes, retired on
It is on 31st December 2007.
31st December 2007.
Yes, ma'am. Died on
Just a minute. Yes. Died
1st September 2016.
retired 31st December 2007
Yes, ma'am.
and died 1st September 2016.
Yes, ma'am.
What is the pension payment order?
Please continue.
No, pension payment order was issued on 7th March 2008.
Madam,
Oh, died on 1st of the years. PPO.
It was 7 March 2008.
Read the dates chronologically. First, you should have indicated the date of pension payment order. The pension payment order is dated 7 March 2008.
Yes, ma'am.
Just a minute. 7th March 2008. Died on 1st September 2016.
Yes, sir.
And you have filed a writ petition in 2023. Yes, sure. Affidavit of service, petitioner's mother was an assistant, was a primary teacher who died, was the primary teacher who retired on 31st December 2007. Stop. On superannuation of the petitioner, by issuing pension payment order dated 7th March 2008, pensionary benefits were released in favor of the mother of the petitioner. On superannuation of the petitioner, on superannuation of the mother of the petitioner, by issuing pension payment order dated 7th March 2008, pensionary benefits were released in favor of the mother of the petitioner. Stop. Mother of the petitioner died on 1st September 2016. Stop. Stop. After date of mother of the petitioner, petitioner being the nominee has filed this writ petition claiming interest on gratuity, which was paid to the mother of the petitioner. Stop. Next paragraph. The learned advocate representing the state respondents has opposed the prayer of the petitioner on the ground of delay. Since mother of the petitioner was a pensioner who retired on 31st December 2007 and pension payment order was issued on 7th March 2008 and thereafter she remained alive till 1st September 2016. Stop. However, mother of the petitioner did not file, however, mother of the petitioner did not approach concerned authorities for release of interest on gratuity. Stop. It is the daughter of the petitioner, being nominee, has approached this court with the present writ petition, which has been filed on 4th July 2023, approximately 7 years after the date of mother of the petition, claiming interest on gratuity, which was paid to her. Stop. Next paragraph. Having considered the submissions made on behalf of the petitioner. Now, next paragraph. Petitioner. Petitioner, in order to explain delay, has relied upon the judgment. Has relied upon the judgment of the apex court reported in 2008, volume 8, SSC 648, within bracket Union of India versus Custom Singh, and has also submitted that since matter relates to release of retirement dues which was payable to her mother and there is no accrual of third party interest, the writ petition. Now, third party interest, the writ petition, third party interest, necessary direction may be given upon the authorities for release of interest on gratuity. Stop. Next paragraph. Having heard the learned advocates representing the parties, this court grants leave to the petitioner to make a representation to the Director of Pension Provident Fund and Group Director of Pension Provident Fund and Group Insurance, West Bengal, being the respondent number 2 2 within a period of 4 weeks from date, claiming interest on gratuity. So, if such representation is made within the aforesaid time, the respondent number 2 shall take a reasoned decision within a period of 12 weeks thereafter, comma, if necessary, comma, after granting opportunity of hearing to the petitioner or her representative. Stop. The reasoned decision to be taken by the respondent number 2 shall be communicated to the petitioner within 2 weeks thereafter. Stop. Next paragraph, with the aforesaid direction, the petitioner shall be disposed of. There shall be no arrest for or number 7. Next. Yes.
Petitioner, died in a petitioner husband, my lord, assisting teacher. High school and died on 7 June 2022.
Yes. Petitioner's husband died.
Yes,
Assistant teacher of high school or primary school?
high school.
Died on 7 June
2020.
7 June
Yes,
2022
yes,
in harness.
yes.
Yes.
PQ issued on 8 June 2023.
PPO 8 June
2020.
2023.
Yes, I am claiming
Interest on that. Wife has come before.
Yes.
State is affidavit of service. Next, husband of the petitioner was an assistant teacher who died in harness on 7 June 2022. Stop. After death of the husband of the petitioner by issuing pension payment order dated 8 April 2023.
Yes, sir.
8 April
8 June 2020.
8 June.
Pension payment.
8 June 2023. Terminal benefits were released in favor of the wife of the deceased teacher being the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. State respondents. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at the rate of 8% per annum on the gratuity. At a rate of 8% per annum to the writ petitioner on gratuity from the date following the date of the husband of the petitioner till the date of release of gratuity, within a period of 8 weeks from the date of communication of this order. The rest of the paragraph will remain same. Disposed of.
Item number 8.
Next.
I'm for the petitioner.
Please.
Petitioner is the head teacher of primary school.
Yes.
Head teacher of primary school and retired on 30 November 2021.
30th November 2021.
Yes, sir.
PPO
PQ minus 16 February 2022.
16th February 2022. Interest on gratuity.
Yes.
Affidavit state. Affidavit service. Next, petitioner was head teacher of primary school who retired on superannuation on 30th November 2021. Stop. After superannuation of the petitioner on issuing pension payment order dated 6th February 2022, retirement dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to direct payment. State respondent. Next paragraph. Accordingly, Director of Pension Provident Fund concerned to pay interest at 8% per annum to the writ petitioner. To the writ petitioner on gratuity from the date following the date of superannuation till the date of release of the same within period of time. Rest of the paragraphs will be changed. Yes.
Husband coming. Petitioner husband.
Wife died in harness.
No, man.
Died. Yes. Wife died. Wife was as a primary teacher.
No, my lord. Husband died. Husband is an assistant teacher.
Husband, primary teacher.
Yes, ma'am.
Died in harness or after retirement?
No, after retirement.
Retired on
On my 27 March 2002.
2002.
Yes, ma'am.
2002. Yes.
PPO is on my 10 March 2003.
Yes.
And petitioner husband died on my 7 February 2009.
7th February 2009. Then
Interest of gratuity.
who is coming? Why?
Why?
So no, we order delay. We order very good. নাকি বলে দেবো
না না সেই আর্টিকেল কি
দেখো বিলের যেটা রিপ্রেজেন্টেশন কনসেপ্ট ঠিক আছে কিন্তু পেজ গুলো মানে বসাতে হবে ঠিক
হ্যাঁ ঠিক আছে সব নম্বর
আমি ফার্স্ট প্যারাগ্রাফটা বলি ফার্স্ট টু প্যারাগ্রাফ avenue of service stop next paragraph husband petitioners husband was a primary teacher. Petitioner's husband was a primary teacher who retired on superannuation on 27 March 2002. So after superannuation of husband of the petitioner by issuing pension payment order dated March 2003, retired dues were released in favor of the husband of the petitioner. Stop. Subsequently, husband died on 7th February 2009. Stop. Wife of the petitioner, wife of the deceased teacher, being the petitioner, has approached this court with the present petition, claiming interest on gratuity. Stop. Next paragraph. The learned advocate representing the state respondents has opposed the prayer of the petitioner on the ground of delay since husband retired on 27 March 2002 and pension payment order was issued on 10th March 2003, releasing retired dues. However, husband remained 7th February 2009, but he chose not to approach the authorities claiming interest on gratuity. Stop. After take of husband of the petitioner on 7th February 2009, wife has also not taken any steps for approximately 14 years and has filed a writ petition and has filed this writ petition on 4th July 2023, claiming interest on gratuity. Stop. Next paragraph, take the same. In order to give explanation of delay data, relying upon a judgment of consultancy, disposed of.
Item number 10.
Yes.
It is my husband when as an appointed teacher of primary school.
When retired?
When I retired on my 2013, 10 March 2013.
And PPO was issued?
PPO issued on my 1st August 2013.
Same order. Husband retired or husband was?
A primary teacher.
All are same matters
No,
of 2013-14.
no, this is also my then 2017 and what the
Yes.
19.
Husband primary teacher. Just in turn. Retired on
10 March 2013, died in Handaka. Died in Handaka.
So, husband primary teacher PPO died down. Died in harness on
10 March 2013.
10 March 2013.
Yes, sir.
PPO
If you issued on my 1st August 2013.
claiming interest on gratuity. Husband of the petitioner, state, avenue service, husband of the petitioner was primary teacher who died in harness on 10th March 2013, and 2013. Stop. After date of husband of the petitioner by issuing pension payment order on 1st August 2014, terminal benefits were released in favor of the petitioner, being the wife of the deceased teacher. Send this to
After the date of the husband of the petitioner, by pension payment,
by issuing pension
by issue of pension payment order on 1st August 2014, terminal benefits were released in favor of the petitioner, being the wife of the deceased teacher.
Stop. The petitioner has approached this court with the present writ petition, claiming interest on gratuity, which was paid to her husband. No, claiming interest on gratuity. Claiming interest on gratuity. Stop. Due to delayed payment. Next paragraph. State respondents are represented by learned advocates. Stop. Next paragraph. Having considered the sufficiency, next paragraph. Accordingly, Director of Pension, Provident Fund, and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner to the writ petitioner on gratuity from the date following the date of husband of the petitioner till the date of release of the same, within a period of 8 weeks from the date of communication of this order. The rest of the liability remains. Next, item number 11. Yes, how much?
4,38,000. On Friday.
Yes, give me the details. Petitioner is coming or the
No, petitioner coming.
Teacher is coming.
Yes, sir.
Yes, petitioner was
Petitioner was
single writ petition or triple writ petition.
no, this is serial.
Petitioner was
Petitioner was a teacher of primary.
primary teacher. Retired on
8 April 2012.
PPO
CPO my lord, 5 December 2017.
whether deposited by on issuance of treasury challan. Very just a minute. Affidavit service. Petitioner was a primary teacher who retired on superannuation. Who retired on superannuation on 8 April 2012. Stop. After superannuation of the petitioner on issuing pension payment order dated 5th December 2017, 8 April 2012. Return after superannuation of the petitioner by issuing pension payment order dated 5th December 2017. Regular dues were released in favor of the petitioner. So, however, petitioner had to deposit rupees 438,158 on being found that the said amount was drawn by the petitioner in excess during his tenure. Stop. Petitioner deposited the aforesaid amount on 20th October 2016 with the concerned authority on issuance of treasury challenge showing such deposit. Stop. Petitioner claims interest. Petitioner claims refund of the aforesaid amount. Stop. Next paragraph, it is submitted on behalf of the petitioner that at the time of processing terminal benefits under the garb of excess drawn amount, no amount can be demanded by the respondent authority. Stop. It is also submitted that this is not a case of misrepresentation and fraud by which petitioner managed to receive said amount during his tenure. Stop. Next paragraph. The learned advocate representing the state respondents has defended a decision of the respondent authorities on demand of deposit of alleged overdrawn amount. Stop. Next paragraph. Having considered the submission made by the learned advocates representing the parties, it appears that the issue of demand of excess drawn amount, which was paid by the petitioner at the time of his retirement for processing his pension case, is no more res integra in view of the judgment of the Apex Court reported in 2015, Volume 4, SCC 334, within bracket State of Punjab and others versus Rafiq Masi, within bracket Whitewasher, bracket close and others, semicolon, paragraph 18 of Rafiq Masi Supra is quoted with paragraph 18. Next, in view of aforesaid decision of the Apex Court, this court finds it apposite to direct the concerned respondent authorities. अच्छा, बड़ा सूट सूट का आज एक काज करो ये ग्राफिक मास सूट का पैराग्राफ 80 next paragraph, in view of the submissions made on behalf of the parties, this court grants leave to the petitioner to make a representation to the Director of Pension Provident Fund and Group Insurance, being the respondent number 2, claiming refund of aforesaid sum within a period of 4 weeks from date. Stop. If such representation is made within the time fixed by this court, the respondent number 2 shall take a reasoned decision on the claim of the petitioner within a period of 12 weeks thereafter, after granting opportunity of hearing to the petitioner or his representative. Stop. Reasoned decision to be taken by the respondent number 2 shall be communicated to the petitioner within a period of 2 weeks thereafter. Next paragraph. With the aforesaid direction, the petitioner has disposed of, there shall be no orders to cause party. Well, yes. Yes.
Return on my 30 June 2017.
Yes.
My lord, first issue is on my lord, 8 June 2017.
Revised PPO.
Revised PPO on the 11th August 2021. I'm getting for see that for getting Europa 2019.
Issue. Stay full affidavit service. Follow the way. Next paragraph. Petitioner was head teacher of primary school, retired on superannuation on 30th June 2017. Stop. on superannuation of the petitioner by issuing pension payment order dated 8 June 2017, withdrawal dues are released in favor of the petitioner. Subsequently, pay of the petitioner was revised in terms of ROPA 2019 rules, and accordingly revised benefits were released in favor of the petitioner. Petitioner claims interest on revised gratuity due to delayed payment. Stop. State respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 14 February 2020 till the date of release of the same, within a period of 8 weeks from the date of communication of this. Rest of the paragraph will even say this.
My lord, 13 and 18, my lord, and useful in this matter.
Very well.
Now, the legal help on composite disputation.
13 and 18 are
Same. At the time of call, learned advocate representing the petitioner has prayed for leave to withdraw the writ petition. Stop. According, state respondents are represented by learned advocate. Stop. Next paragraph. In consideration of the submission made on behalf of the petitioner, the writ petition stands. The writ petition is dismissed as withdrawn. এটা কি ঠিক আছে 13 and 18
18, my lord.
13 and 18.
দুটোকে একসঙ্গে করো তো 13 and 18 একটা সেম অর্ডার করে both the writ petitions are taken up for consideration in presence of the learned advocates representing the petitioner and the state respondent. Next paragraph, learned advocate representing the petitioner submits that inadvertently two writ petitions have been filed by the same petitioner. Therefore, leave is granted. Therefore, leave is paid for to withdraw both the writ petitions with a leave to file a composite writ petition. Stop. Next paragraph. In view of the submission made on behalf of the petitioner, both the writ petitions stand dismissed as withdrawn with leave to file a composite writ petition. Stop. Urgent xerox certificate for 14.
This matter is to become item number 9. Because similar matter was yesterday in the item number 103 also. Both are
15, my lord, I want to withdraw.
14 and 15.
Yes, ma'am.
15 also.
And 94 yesterday was not taken up.
Yes, but same pattern. But in the yesterday place, I have that is why I am written it down. 14 and 15. Name of the petition is same shortly.
So I am passing an order directing that let these three writ petitions, these along with the 94 yesterday's list, be taken up together before the on the first day of the on the second day of the next circuit.
Yes.
That will be appropriate. 94. Give the details of writ petition 94.
Yes.
Yesterday's list is out. 94 about. I am not imposing cost since petitioner is a pensioner. Yes. কত নম্বর আছে 14 is today's 94.
Yes, and similar matter to the yesterday is 113 also.
113
Yes.
দেখো তো
Similar matter.
নীলামণি রায় এটা নীলামণি রায় তো আইটেম নাম্বার 14 and 9 yesterday list 115 there have Nilamoni has filed two writ petitions.
No, my lord.
Nilabari has filed repetition lordship yesterday. It was coming to 94 and 113. Yes, ma'am.
Then 15 is defined matter.
15 what one I am withdrawing this repetition because
And the 14?
14 deal money right.
Yes, another writ petition is there, which appeared yesterday, which appeared in the yesterday's cause list as item number 113. Very well, let these writ petitions be heard together, then you will satisfy the court. Well, then you will satisfy the court that there are two writ petitioners.
Yes, ma'am.
Very well. Item number 14, record an order. At the time of call, at the time of call, learned advocate representing the state respondents submits that apart from WPA 1440/2023, same petitioner has filed another writ petition being WPA 1484/2023. So, next paragraph, in view of such submission made on behalf of the state respondents, let both the writ petitions being WPA 1440/2023 and WPA 1484/2023 be heard analogously on the next date. Next paragraph, let both the writ petitions appear on the second day of the next circuit, subject to convenience. Stop. Fourteen. 15 is telling which matter? I don't know. 15 is telling which matter? Peculiar practice has been developed. Chandra Kumar Rai. 106. 1457. 1441. Right. 106. শোনো, এটা রিপিটিশনটা এটা করো, এটা আইটেম নাম্বার 15, আইটেম নাম্বার 15 106 15 এর উপর অর্ডারটা করবি, চন্দ্র কুমার রায় 1441/2022, ঠিক আছে, এটার উপর অর্ডার করবি। At the time of call, learned advocate representing the state respondents submits that same petitioner has filed another writ petition being WPA 1457/2023. Stop. Next paragraph, having considered the in view of such submission made on behalf of the state respondents, let the present writ petition be WPA 1441/2023 be heard along with WPA 1457/2023 on the next date. Stop. Next paragraph, let both the writ petitions appear analogously. Now, let both the writ petitions be tagged together, and appear in the list on the second day of next circuit for further consideration. On the second day of next circuit, subject to convenience for further consideration. Yes. Yes, 16. Withdrawing.
No, in case of gratuity.
Petitioner
Assistant teacher of high school.
retired
Retired on my 30 November 2019.
PPO
PPO my lord 27 2023.
27 March.
27 March 2023.
Interest on gratuity. Petitioner was affidavit of service. Petitioner was assistant teacher who retired on superannuation on 30th November 2019. Stop. On superannuation of the petitioner by issuing pension payment order to 27th March 2023. 30th, retired on superannuation on 30th November 2019. Stop. On superannuation of the petitioner by issuing pension payment order dated 27th March 2023. Retired dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocate. Next paragraph, accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of the same within a period of 8 weeks from the date of communication of this order. The rest of the paragraph will be inside this fourth. Yes, item number 17.
On the right of the petitioner.
Yes,
Petitioner husband
when died?
my lord petitioner died on 24 December 2021. Died in 150.
Husband was
Husband was a group staff of high school.
on
My lord died in 24 December 2021.
wife has come.
Yes, my lord.
PPO
PPO my lord 17 May 2023.
wife is claiming interest on gratuity. Affidavit of service. Next, petitioner, husband of the petitioner was non-teaching staff of a high school who died in harness on 22nd December 2021. So, after death of husband of the petitioner, after death of husband of the petitioner by issuing pension payment order dated 17th May 2023, terminal benefits were released in favor of the petitioner being wife. So, petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of death of husband of the petitioner till the date of release of gratuity within a period of 8 weeks from the date of communication of this order. Rest of the paragraph will remain same. Disposed of. Item number 19. Yes, 19.
Petitioner wife my lord assistant teacher of my lord.
Wife of the petitioner was assistant teacher.
Yes, my died in 100.
Wife assistant teacher of primary school.
Yes, my
Assistant teacher of primary school.
yes, my died on my lord.
Just a minute. Died in harness on 4th January.
Yes, my lord. 4th January 2020.
PPO,
this one 31st March 2023.
interest on gratuity,
Yes, madam.
31st March 2023.
Yes, madam.
Affidavit of service next. Wife of the petitioner was an assistant teacher who died in harness on 4th January 2020. Stop. After death of wife of the petitioner, by issuing pension payment order on 31st March 2023, terminal benefits were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to deductible. Stop. Petitioner being the husband of the deceased teacher, petitioner being the husband of the deceased teacher claims interest on gratuity due to deductible. Stop. Next paragraph. State respondents are represented by learned advocate. Who is for the state? Stop. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned reserves are directed to pay interest at a rate of 8% per annum to the petitioner from the date following the date of husband of the following the date of husband following the date of death of wife of the petitioner till the date of release of gratuity within a period of 8 weeks from the date of communication of this order. Rest of the paragraph will remain same.
And for the petitioner.
Item number 20.
Revised PPO number 2019.
Petitioner was
Assistant teacher of high school. Return
just a minute. Retired
28 February 2007.
28 February 2007. PPO
First PPO 15 June 2015.
revised PPO
27 April 2023.
27
April
2023.
2023.
Oh, retired on 2007.
Yes, ma'am. Rupa 2019. Revised.
How Rupa 2019 can be applied in case of the petitioner? Well, from which date Rupa 2019 comes into effect?
And 14 February 2023.
No, from which date Rupa 2019 comes into effect?
14 February 2020.
Probably from 1st of January 2016. So how Rupa 2019 comes into play?
But revised people are 27 April.
How can it be if a person retired on 28 February 2007 and first PP was issued on 15 June 2015? Then he is not coming within the ambit of Rupa 2019. Whether today a teacher can claim that he is claiming the benefit under Rupa 1990? Certainly not. Record an order. By filing the present writ petition, petitioner has claimed benefit of Rupa 1990.
Rupa 2009. Sorry.
Rupa stated that
Rupa 2009.
find is a box.
Yes.
Rupa 2000.
Where is the revised PPO? Let me see.
No.
Where is the revised PPO?
No, revised PPO is not.
Revised PPO cannot be in 2023.
No. Rupa 2009.
Withdraw the writ petition with better particulars. Yes. We are before a different court. All matters cannot be considered in the same manner. That's why I am taking a note. At the time of call, learned advocate representing the petitioner prays for leave to withdraw the writ petition. Now, at the time of call, learned advocate representing the petitioners submits that the petitioner is willing to withdraw the writ petition with a leave to file afresh. Stop. Next paragraph. Stop. Next paragraph. State respondents are represented by learned advocate. Stop. Next paragraph. Considering the submission made on behalf of the petitioner, the writ petition stands dismissed as withdrawn with leave to file afresh with greater particulars.
Item number 21.
Yes, petitioner was
Assistant teacher of a primary school. Retired on below 31st May 2018.
31st May 2018.
First PPO was on below 29th August 2018.
29th August 2018. Revised PPO
13 November 2020.
Ropa 19. Petitioner was a affidavit service. Next, petitioner was a primary teacher who retired on superannuation on 31st May 2018. Stop. On superannuation of the petitioner by issuing pension payment order dated 29th August 2018. Pensionary benefits were released in favor of the petitioner. Stop. Subsequently, pay of the petitioner was revised in terms of ROPA 2019 rules, and revised pension payment order was issued on 13th November 2020, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Stop. State respondents are represented by learned advocate. Stop. Next paragraph. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned registered officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order within a period of 8 weeks from the date of communication of this order. Rest of the paragraphs will remain same. It is posted.
22.
Yes.
Yes. Whether he is coming under the Director of Pension Provident Fund Group Insurance.
No, account general government of West Bengal, PPO
Whether any similar matter is there, where this court has passed an order again, so far accountant general is concerned. Show me. Then otherwise matter has to be heard, because since the petitioner is not under the same directorate, then what is the stand of the directorate that needs to be taken into consideration. So very well, I am directing Mr. Ghosh, so able advocate, to obtain instruction from the directorate regarding the claim. And yes, you are claiming interest on gratuity. Revised ROPA 29. Let it be considered after obtaining instruction. Because this court is passing order with regard to Panchayat and Panchayat employees and the primary and secondary teachers, because these issues are covered by the judgments of up to division. So that's why, since this is an issue which is coming under the purview of different directorate, so therefore it needs to be taken into consideration after considering the view of considering the stand which is to be taken on behalf of accountant general. The writ petition is taken up for consideration when it is submitted by the learned advocate representing the petitioner that the petitioner was a non-teaching staff. Yes, petitioner was a non-teaching staff of a government aided college. And now petitioner is a retired non-teaching staff of a government aided college, claiming interest on revised gratuity after pay of the petitioner was revised in terms of ROPA 2019 rules. According to the petitioner, respondents may delay in releasing revised benefits in favor of the petition. Stop. Next paragraph, Mr. Vikramaditya Ghosh, learned advocate, is representing The Director of Public Instruction, DPI, Director of Public Instruction, Government of West Bengal, as well as Accountant General, you are not appearing. Director of Public, have you served upon Accountant General? Then Director of Public Instruction, Instruction, Government of West Bengal. Stop. Mr. Bose is directed to obtain instructions in this matter. Stop. Let the matter be listed under the same heading. Before under the same heading, your circuit is commencing from 24th July.
Yes, that is also revised.
Yes. We have also got notification. Very well. Let the matter be listed on second on 1st August 20. Let the matter be listed on 1st August 20. Even if it starts from 24th July, so it will be for a period of two weeks. So therefore on 2nd of August you are getting circuit.
Yes.
So or on 1st of August, let the matter be listed on 1st August 2023 for further consideration. Stop. Next paragraph. The learned advocate for the petitioner is directed to serve notice upon non-appearing respondents, enclosing copy of the order passed by this court today, and file affidavit of service on the adjourned date. Next,
23, item number 23.
college, same order, Mr. Ghosh is appearing, DPI, then record the name of Mr. Shah instead of Mr. Ghosh. Yes, next matter.
24.
Record an order. At the time of call, learned advocate representing the petitioner prays for accommodation. Stop. Let the matter be listed before the next circuit, subject to convenience. Next,
25. Appearance 7 from
item number 25.
25.
Take the file time. At the time of call, at the time of call, no one appears for the petitioner and no accommodation is paid for. So, in order to give one more chance to the petitioner, let the matter appear on the 2nd day of next circuit, subject to convenience for further consideration. Next,
26.
you are appearing for the petitioner. Make a note that Mr. Ravan is appearing for the petitioner against Mr. Chaudhary.
Actually, when I civil dispute, page 93, when Board of Justice Mantra, they are asking for the by your writ petition for entering into the land who are armed with the rich court sword.
So if there is an order of this court.
No, Mantra said, it is a civil dispute. You are clause 156 or clause 3 and file a civil suit. Clearly stated 93 page. He is sitting at a accommodation all the time. I am not. But tell me, look of 93.
126 subclause 3.
156 subclause 3.
Oh.
Progress of investigation. Non-registration.
156 clause 3 of self-is.
Non-registration, registration, and as well as the progress of investigation.
That's an entirely different process.
Very well. At the time of call, Mr. Muminur Rahman, learned advocate representing the petitioner, pays for accommodation. Stop. However, state respondents are represented by Mr. Joy Chaudhary, learned additional advocate general. Stop. There I am not recording any observation that will go against.
Lordship.
Stop. Next paragraph, acceding to the request made on behalf of the petitioner, let the matter appear before the next circuit subject to argument.
27.
And for the particular started not yet the new matter and you put the recommendation.
It was not heard before. At the time of call, no one appears for at the time of call, accommodation has been paid for on behalf of the petitioner. Since service of notice upon the respondents is not complete. Next paragraph, release the matter before the next circuit subject to convenience in order to enable the learned advocate representing the petitioner to complete service upon the respondents. Next,
28. Under here. I'm happy to.
And for the state.
Lordship, your petitioner before the lordship. Made a Nepal year before the Total station in the year 2040, 2040. And charge sheet was completed after 6 years in the year 2020.
what was the charge?
Allegation was under 420. Quantity of the signature of the petition. Now the signature of the petitioner was sent by the investigating officer to the respondent of QED for verification.
This one number 4. Question documents bureau.
Yes. Now the charge sheet was completed after 6 years without the verification report. And
Now the investigating officer has sent it to the question document examination bureau for getting the report with regard to the genuineness of the signature.
that report has not come.
When it was submitted,
In the year 2020, the charge sheet was
Submitted.
They are submitted.
yes,
Lordship supplementary charge sheet was submitted because we did not get the collected
No,
report.
supplementary charge is not submitted with the negotiation.
Actually, their parents to consider their recommendation. Because
who will consider the representation in a criminal investigation matter?
their parents that.
They have to file
That is
the,
the having to be
they
the.
have to file the supplementary charge sheet as a national report.
Lordship page number 11. In the bottom there, mentioned that consider the representation on petitioner dated 27/6/2023.
That is the page number 2.
Yes, what sort of prayer is this?
Sir, that is page number 12.
No, what this court will go by the prayer.
They are asking for the court to go by the prayer.
You have prayed, it is your petition, Mr. Counsel. You have prayed for consideration of your representation.
Read the whole prayer.
Yes,
And direct the respondent number 12 to submit the supplementary charge sheet before the learned CGM judicial magistrate to authorize the operation.
so is it your case, madam, that supplementary charge sheet has been filed?
No,
Lordship, I will come back to the instructions. Can you please the matter?
Since yes, there is a his prayer is not correctly prayer is not happily drafted, but there is a prayer that let a supplementary charge sheet be filed.
Please, Lordship.
So if you don't get the report from question document bureau, examination bureau, then will you be able to file supplementary charge sheet?
It can be Lordship. If the land decision will allow.
On what basis?
Lordship, that they are this requesting the for filing the final charge sheet because already date is expired. That is why.
we have paid for supplementary charge sheet along with the document. So if the document
They have prayed for filing of supplementary charge sheet
is
before the
court below,
Yes.
along with the document supplied by the QBD. Now, my instruction is that QBD has already supplied the document. They are intentionally not.
Lordship, I will.
very let them take file a report with regard to filing of supplementary charge sheet before the learned judicial magistrate 74. The writ petition is taken up for consideration in presence of the learned advocates representing the petitioner and respondent number. You are not representing question document examination board. Respondent number 1, 2, and 3. Stop. The grievance which has been voiced on behalf of the petitioner is failure on the part of the investigating officer in connection with GR case number 1645 of 2014, corresponding to Kotwali Police Station case number 311 of 2014, dated 3rd April 2014, under section 406/420/468/471/506/34 of the Indian Penal Code, that supplementary charge sheet has not been filed till date in spite of receipt of report from Question Document Examination Bureau within bracket QDEB, being respondent number 4. According to the petitioner, for expediting the criminal proceedings pending before pending before Judicial Magistrate Second Court, Jalpaiguri, filing of a supplementary charge sheet on receipt of report from QDEB is necessary. Next paragraph, the learned advocate representing the petitioner has prayed, learned advocate representing the state respondents has prayed for accommodation to file a report. Stop. Let such report be filed within fortnight from date. Stop. Next paragraph, list the matter before the next available circuit for further consideration. Yes.
The next date for the evidence is on 22nd of August. Before that,
Yes. Fortnight. Fortnight from date. And after fortnight, you are getting a continuation of circuit.
Let them hand over a copy of the.
And let it be filed before the court first.
Not that way. On the evidence.
The evidence service filed. Yeah, have you served upon QDEB?
Well, I had sent, but it was not served.
Well, evidence service filed on behalf of the petition is taken on the record. Add a line.
29.
State housing director.
Who are you? Yes.
Your service is complete.
You are the private respondent.
Yes.
Respondent number 4. Yes. No, mail service will not. I don't accept allow mail service. He is the affected party. It's a tender matter. You mentioned this matter yesterday in view of urgency. I remember it very distinctly. It's a tender matter, and he must have been a selected person.
He is a L1.
Then you are mentioning the matter every day without taking steps. Today, if your petition is allowed or any order is passed in favor of the petitioner, that is definitely going to affect the respondent number 4. On the next day, sorry, very sorry. Sorry. Certainly not.
Here's how the matter.
What is the use of hearing you?
After that,
What if I proceed on the basis of premise that I am satisfied with regard to the prima facie case, I will not be able to pass any order, because any order stalling the tender, please hear me. Any order stalling the case tender proceeding will affect the interest of L1 bidder.
kindly hears me for a moment. Kindly
Yes,
hears.
sure.
Kindly hears me.
Every day you have at least mentioned this matter 2 or 3 times.
Only once I mentioned yesterday.
And very well. Yesterday you mentioned you are not taking steps with regard to service.
Sir, matter is hard, below.
Very well, on 24th. From 24th you are getting. Let it be on the first day of the next circuit. Let it be on the first day of the next circuit.
Kindly, Milord.
Then why you are not served? Tell me. Email service of the writ petition, is it possible? Show me that you have sent a document. You have sent the hard copy of the writ petition. Show me.
Hard copy could not be sent due to person.
Yes,
For 5 days.
The writ petition is taken up for consideration. In presence of the learned advocates representing the petitioner, representing the petitioner, former state respondents, state respondents and respondent four. The writ petition is taken up for consideration in presence of the learned advocates representing the petitioner, respondent number 1, 2, 3, and 4. Stop.
No, 4 melon.
And 4.
4 is.
Yes.
Your kindly bears with me.
Matter relates to
Consider the
relates to a notice of tender. Notice, matter relates to tender. Matter relates to a tender proceeding
I am
or tender.
already dictating to
Is it the way to address the court? How long you are practicing? You will not serve copy. You will go on mentioning at the time of call. If the main affected party is submitting that he has not been served with a copy of the writ petition, and he will disturb the court. Shall I refer the issue to the bar council? You should know, maintain the decorum. You are before the High Court.
otherwise.
What is this?
But I did not have
Petition is taken up for consideration in presence of the learned advocate, including the petitioner, number 1, 2, 3, and 4. Stop. Matter relates to
A tender process which has been questioned by the petitioner in the present writ petition. Stop. Next paragraph, Mr. Joyji Chaudhary, learned additional government, additional advocate general. Additional advocate general submits that respondent number 4 is the L1 bidder. Stop. Next paragraph, in view of such submission made on behalf of respondent number 1, 2, and 3, it appears respondent number 4 is a necessary party and petitioner has added the L1 bidder as respondent number 4 in the present writ petition. However, the learned advocate representing the respondent number 4 submits that. However, the learned advocate representing the respondent number 4 submits that he has not been served with that his client has not been served with a copy of with hard copy of the writ petition. Therefore, today he is appearing before this court without the copy of the writ petition. Stop. Next paragraph, the learned advocate representing the petitioner is directed to hand over copy of the writ petition in course of this day. Yes. In course of this to the learned advocate representing the respondent number 4. Stop. Next paragraph, considering the urgency as expressed on behalf of the petitioner, let the writ petition appear before let the writ petition appear under the same heading, or let the writ petition appear under the same heading. Let the writ petition appear before the or let the writ petition appear on the first day of the next circuit, subject to convenience for further consideration.
I taken an unconditional approach.
Take it back, file a complete affidavit serve. Don't disturb the court in this matter. Try to appreciate that today, if I am satisfied with your case, I will not be able to pass any order. Don't neglect this procedural issue. Mr. Counsel, you are the junior advocate of junior member of the bar. Don't neglect this procedural issue.
And after dictating the order, you have want to submit anything you can.
Yes.
Then option can consider.
Otherwise,
Leniency you can be taken, but if you go on, disturbing the court, it will be. You have a
and what will be the atmosphere of the court in that event? Try to appreciate.
I didn't know my largest friend was that hearing.
You mentioned the matter. I remembered this. Yesterday you mentioned this matter. But and since this is the last date, some of the matters were to be excluded, but I haven't excluded your matter from the list, considering you are mentioning yesterday. But if you have not completed the groundwork, what can be done?
For the next packet, it's something going on.
We are here to take up the matters, and especially urgent matters. Yes.
Item number 30.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, list the matter before the next circuit for further consideration.
31.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, in order to give one more chance to the petitioner, list the matter before the next circuit under the same heading. List the matter before the next circuit for further.
32. Item number 32.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, in order to give one more chance to the petitioner, list the matter before the next circuit, subject to convenience for further. Subject to convenience.
Concluded your lordship.
Yes. I have tried to reach all of
It is an extensive, my lordship is endowed.
only Mr. Ghosh is not satisfied because I have yes, my recalling application, and that recalling application has been mentioned, but I have told Mr. Ghosh that it will be better if you move this recalling application before another one.
আমার নামে কি লাগে যে রিটেনিং হলো তো তার পানি তুলে দিল যে রিটেনিং আমি জানি কালকে যে আমরা এক্সেপ্টিভ
आपसे मेरा का छोटे छोटे नाम
তাদের ব্যাপারে কাল ছিল এক্সেপ্টিভ
তোমার এখান থেকে ঠিক ঠিকেছে তো তোমার আগে দেখো আমাদের সাহারা ঠিক আমার
না নাম করছি কি
এই আপনি অফ করে দিন